Mr. Davis has really gone above and beyond. When it happened, I thought I was going to lose my mind during the case, and he's kept me calm. But having the knowledge that he has really helped a lot. And he knows what he's doing. He knows how the system works, and that's something that I entrust in my life with him. My daughter's my life. Everything within this case has not been easy, but he stepped in and he took charge of the case. And
Good morning. I'm Vince Davis, and this is my office hours. I'm joined by my co-host, Miss G. Good morning, Miss G. How are you?
I'm good. How are you? Good morning.
Good morning. So you have questions for me today regarding what, the 388 petition?
Yes. I have question number one. What exactly is the 388 petition, and why is it so powerful in a CPS case?
Well, basically, the 388 petition is a petition that a parent, anybody, to be honest, anybody can file a 388, but it's most often used by parents to change court orders that have been previously made because the parent has evidence of a change in circumstances, and they can show that it is in the best interest of the child. So, for example, let's say your family reunification services have been terminated and you're moving towards the termination of your parental rights. You can file the 388 to get your reunification services back and even get the child placed with you, or even perhaps get the child returned to you, or get unmonitored visitation, or get the child placed with a relative or a family friend. So it can be used to change a lot of things. I've actually seen it used to get a child back that had already been terminated and adopted by someone, to reverse an adoption. Now, that's highly unlikely, and I originally told the person they couldn't do that, but they did it. It was some very unique circumstances, but basically a 388 is a get out of jail free card.
Okay. All right. Question number two. Who can file a 388 petition? Is it just the parents, or can relatives and or other use it as well, like friends, best friends, and close friends and all that, or neighbors even?
Yes, I think the statute reads any person, so any human being can file a 388.
Okay. Now, number three of my questions: what makes the 388 different from an appeal or a review hearing? A lot of people want to know that.
Well, first of all, an appeal is done in a different court, in a higher court. A 388 is done in the trial court. A review hearing is done every 6 months in the trial court. A 388 is done anytime you want after the disposition hearing. There's no set schedule, and there's a time frame in which a 388 must be heard after you file it. So those are the primary differences.
So how come, I guess my next question would be, how come a lot of parents don't know about this, and they can't, or not even use it in the right way? You know, they don't know about it and they don't use it the right way. They hear about it, but they don't know how to use it properly.
Well, you know, I can't tell you, but it's probably different for every parent. Maybe they haven't discussed it with their attorney. Maybe they haven't watched my videos on YouTube. I don't know. I don't know why people don't know things in the law. I mean, they're not born with this knowledge. Somebody has to tell them.
No, but I mean, I guess my point is, in question number 4 of my list, is that why don't their court-appointed attorney address this with them? Because
Georgette, I'm not a mind reader. Come on. I don't know why they don't discuss it with them.
Okay, number 5. When is the best time to file a 388? Is earlier better, or should parents wait?
Earlier, the better. But it has to be at or after the disposition hearing. Don't go to the detention hearing and get a bad ruling and think you can file a 388. Procedurally, you can't. Although I have to say, I've seen people file 388s, over this, 35, 36-year career, file them prematurely. And on a couple of occasions, I've seen judges deal with them, even though, in my humble opinion, they weren't supposed to. But I guess, you never know until you try.
True. Okay, my question number 5. When is the best time to file a 388? Oh no, I did ask you. Sorry. Okay, number 6. What type of changed circumstances qualify to trigger a 388?
A change that is in the best interest of the child.
Can
Now
you give an
that's,
example?
yeah, having the child move to a relative placement. The law presumes that a relative placement is better than a foster care placement. And let's say grandma didn't know about the case and suddenly finds out and comes forward and says, hey, place the baby with me, or place the child with me. Relative was just discovered. Social worker didn't know about relative before. And now we have a change. Social worker now knows, and now place the child with grandma. Sometimes social workers will argue against that for whatever reason, but that's an example. Or parental rights are not parental rights, but family reunification services have been terminated. And, all of a sudden, mom or dad has completed the case plan, done more drug testing, finished the counseling, done the individual counseling, has glowing letters and progress reports. That's a changed circumstance. And, they've been visiting with the child, and, the child has a bond with them, emotional, psychological, and physical bond with them. And it would be best, it's presumed, that the
Mhm.
child be returned to the parent or parents.
Um, how much proof does a parent need to file one?
Well, you probably need something called the preponderance of evidence that you need to prove to carry the day in order to, number one, get a hearing. You have to state what's called a prima facie case. And then if you get a hearing,
Mhm.
you have to prove by preponderance of evidence that there's been a change in circumstances. And then on top of that, you have to prove that it's in the best interest of the child. I see a lot of cases where the judge denies a 388 because you haven't stated or shown that there's a prima facie case. And then if you do show it, I saw a hearing not too long ago that the judge determined that it wasn't in the best interest of the child to make that change
Wow. And when the judge decides to do that, is based on what?
based upon the evidence presented before the court. Now, you don't have to agree with the judge because the 388 can be appealed.
Can a can a can a parent file more than one 388 during a case?
Yes.
Thank you. Does the social worker file a report opposing the petition, the 388
Social,
petition?
yeah, the social worker can file a report either opposing it or supporting it. I've seen both.
Hmm. What is usually in that report, the social worker's report, and how should parents fight it?
Well, if it's a report that, is against them, they
Of
should
course.
fight it like any other report. Um, Subpoena in the witnesses that the social worker claims are testifying against them. Subpoena in the social worker to be cross-examined, and bring their own witnesses to testify. For example, I did a case yesterday, and my client said I'm concerned that the social worker is so against me. And I said, don't be concerned, because I've talked to all of her service providers, and they're all going to come in and say great things about you and your progress in the case. So nothing to worry about. As a matter of fact, the judge, without solicitation, gave us a tentative ruling, and it was to return the kids to my client, because she said, look, these kids are older. They're like 15 and 14 and 11. And she said, all of the service providers are saying mom made such a great change since the last hearing. Like, why aren't we giving the kids to the mom? And that seemed to spur the child's attorney and the county counsel, social worker's attorney, to be even more adamant against my client. I'm not sure why. I'm new to the case, and there seems to be some personality conflict between the social worker and the mother. I don't know why yet, but I'm delving into that.
So what tactics do the social worker use to shut down the 388?
To show that there's no change in circumstance, or to show that it's not in the best interest of the child to be moved.
Okay, once filed, what happens next? Is there a hearing after you file the 388, the parent?
Yeah, now the way they're doing it, and I think the code was actually changed, the judge usually sets a hearing to determine if there's a prima facie
Right.
case. So they set a hearing to determine if there's going to be a real hearing on the 388. So you go to court and you usually argue whether there's going to be a hearing, whether you stated a prima facie case. And if you win that, then the judge sets a real hearing where you come with evidence and witnesses to prove your case. Although I've had it on occasion recently, even, where the judge just sets a hearing. The judge just decides, you know what, Davis, stated a prima facie hearing. We don't have to have a prima facie hearing. Let's just go straight to the hearing. So the judge can do that too. Also, let me tell you this. The judge can grant the 388 or deny the 388 without any hearing. And I've seen that happen, several times throughout my career.
Interesting. Okay, I have another question. Once the 388 is filed, what should a parent expect at a contested 388 hearing?
The parent can expect, since they have the burden of proof, to call their witnesses, to present their documentary evidence, to try to prove the two things I told you earlier that you have to prove.
Right.
And then you can expect that the other parties in the case will either support you by calling witnesses or oppose you by calling witnesses and presenting documentary evidence.
Gotcha. How can attorneys use cross-examination and exhibits to win the hearing, the 388 hearing?
To do what?
I'm sorry. What are some? How can attorneys use cross-examination and exhibits to win the hearing?
Just like any other hearing, you cross-examine witnesses, say the social worker, to show that the social worker is not credible, to show that the social worker her assumptions are faulty, to show that the social worker is biased, show the social worker may have some type of personal conflict with, the client, and to show documents that prove that the social worker's statements are simply just not true.
Okay. What are some examples of strong evidence you've used to win a 388?
Testimony by my clients' counselors and service providers. For example, social worker will say, well, Davis's client hasn't learned anything in her anger management class or counseling, or the domestic violence counseling. And I bring in the counselor who says, oh yeah, Davis's client was a stellar client, has learned and progressed in the domestic violence class, and has become a totally different person. And if you can get them to say that Davis's client would not be a risk to the child, that's almost a slam dunk. A lot of therapists won't say that because they're not allowed to predict the future. But every once in a while, some therapists will say that.
Hmm. What kind of witnesses help strengthen a 388?
The parent, him or herself,
Hmm.
the service providers, sometimes the cross-examination by the social worker to show that he or she, does not really know what they're talking about.
But can neighbors also be part of this? Like, you know how
Neighbors,
neighbors are close, become close family friends, you know?
neighbors, character witnesses, family members. Yeah.
How about hospitals, nurses, doctors?
Well, they can, but generally hospitals, nurses, and doctors aren't relevant at a 388. They would be relevant at the beginning of the case
Mm,
regarding abuse, right? But they're not relevant at a 388 generally.
okay.
That's why it's important to know like what stage of the case you're at, because you'll notice that when I talk to people, I ask them what stage of the case you're at, because then my mind goes to that pigeonhole, and I start thinking about what are some of the issues that come up. And some of the issues that come up for 388 are different from what the issues would be at a detention hearing or at the disposition hearing or maybe at a 6-month review hearing or at a 2-6 hearing. So that's why you always have to know, well, what procedural posture are you at? Get it?
That I get it. It's
Okay.
just hard for parents to get it when they're dealing with it, and their attorneys are no.
That's why they call us. That's why they listen to the YouTube channel.
Right. How important are written declarations from witnesses?
To get the 388 filed and to get that prima facie hearing, it's extremely important. And generally, if you're going to have a 388 hearing, generally the social worker's attorney and or the judge will probably require those witnesses to come to court and testify, or at least testify online if, for example, they're out of the county or out of the state. But you have to get permission from the judge to allow them to do that.
Okay. What kind of documentation should be submitted before the hearing?
It should be submitted with your 388 petition. For example, your progress letters, your completion certificates, your character letters, uh, letters from recipient witnesses, declarations from the visitation monitors, that type of thing.
Okay. In your opinion, what are the biggest mistakes parents make when filing a 388? And I've seen that happen all the time. I know what it is, but
They try to do it themselves.
yep.
And the 388 form itself is about 4 pages. You can get it online. But if you fill out the 4 pages, that's not a 388. The 388 needs exhibits, declarations, that type of thing. We have a case up in Northern California right now. We came on the case and we prepared a 388 that was over 200 pages. Now, the form itself is 4 pages. We
Mhm.
prepared a 388 that was over 200 pages. Within 1 or 2 weeks, the social worker wrote an email to everyone saying, "Oh, I recommend that the parents have unmonitored visits." Now, my client believes the worker did that because he read our 388, and it basically, if the worker didn't recommend that, it basically made the worker look like, he didn't know what he was doing because the evidence was so overwhelming.
Is
So
there a
388
I'm
388
sorry.
can be used to as a weapon as well to force people like social workers to do certain things.
Is there a wrong time to file the 388, or too early or too late when it comes to the 388 to file it?
Yeah, when you don't have the evidence to support it. You don't want to file a 388 when you don't have the evidence, because you're going to use up the credibility that you have with the judge. These judges remember, all right? And if you file a 388 that isn't supported by the law, you're just wasting the judge's time. Judges are too busy, especially in these counties where there are a lot of cases. Like,
Wasn't
oh,
there wasn't there a client, not a client, but somebody we know that their attorney filed a 388 after during the same day as the trial? Do you remember that guy?
Yeah, you don't want to do that because 388 causes the parent to have the burden of proof.
Mm-hmm.
Okay. But at a review hearing, the social worker has the burden of proof. So you never want to have your 388 on the same day or at the same time as a review hearing. Now, here's something interesting. Yesterday, I appeared on a case in a county. I won't say what county it was. And the case was being continued for a contested 6-month or 12-month review hearing
Mm-hmm.
and for contested 388. And I was new to the case. And I realized that the mother's previous attorney had filed a 388.
Mm-hmm.
And I told the county council, I said, I don't want a 388. I don't want my client's 388 to be heard. I'm withdrawing it. And she kind of looked at me like, oh, he knows what he's doing. The reason why I don't want the 388 to be heard is because I have the burden of proof. But at a 6-month or 12-month review hearing, that same issue is before the court. And the social worker has the burden of proof. So on the record, when we went on the record, the judge says, I understand, Mr. Davis, that you're withdrawing that 388. And I said, yes, I am, Your Honor. And the judge kind of looked at me, nodding like, okay, he knows what he's doing.
Makes sense. You do know what you're doing. How do parents hurt their own petition without realizing it? And that happens a lot, Davis. You know that.
They try to do it themselves. They try to come up with their own legal strategy. It is their case. It is their family. It is their money. But, even though it's America, they don't have the knowledge or experience.
Nope.
And it's so hard for a lot of people to accept that. But, it's the example I always use. If the doctor tells you, hey, Georgette, you need open heart surgery, are you going to try to Google it and figure it out for yourself? You probably would, but you probably
Really?
shouldn't. You probably shouldn't do that. It's not a good idea to determine if and how you should do your open heart surgery. Most people understand that, but for legal things, you feel like, oh, I can do it myself. I can represent myself.
Honestly, when it comes to the children, it's very you shouldn't do anything that will jeopardize the case. That's a very sensitive case.
I talk to a lot of people that say, hey, I can't afford a private attorney, and I understand that. And I tell them, well, use your court-appointed attorney. And they get mad at me. Look, any attorney is better than no attorney. Okay? So learn how to get along with your court-appointed attorney and work with him or her. Because any attorney is better than no attorney.
And also make sure you have paper trace for everything with your attorney.
Yeah.
Meaning that court-appointed attorney, instead of calling, email, right?
Absolutely.
Okay. How can viewers in other states find their version of California 388, which is good?
They're going to have to ask their attorney. Or they may Google it. We had a host that used to do one of our shows. I'm trying to think of her name. I think she was on the show the other day. She was posting comments. She was back east. I think she lived in Virginia. Oh, what was her name? She found a website that translated the law from one state to the law from another state. You could input like California 388, and you could find that law in Virginia, or in New York, or in Arizona. So those types of internet sites do exist. Or you can simply call up your attorney or email your attorney and ask him or her.
Can someone hire a private investigator or a private services to monitor the monitor during a visitation and write their own report of what they see, the interaction between the parent? And that's not one of the questions on my list, but this is very important for me to know because I need to call a client today.
In California, I would say yes. If they're out in the public.
Yes, it's in the park.
Yeah. So you're out in the public space, so you're open to the public.
Now, if the report of the private investigator and the report of the social worker are completely opposite, contradicts itself, what happens then? Like if the social worker says the parents have no
I
relationship
get
with
it. I
the
get
child,
it. Let me answer it. Let
oh,
me answer it. The social worker will testify, the private investigator will testify, and then the judge will determine who's telling the truth.
okay. What should someone never put in a 388 declaration?
Never put in a 388? That's a good question. I've never thought of that question. Probably something that's incriminating or, admission against your interest.
Um, hmm. Is there a federal principle that supports this type of modification in the
The federal principle, the closest thing that I can think of is due process.
mhm. Can someone file a 388 even if their case is closed or termination happened?
The answer is yes. Doesn't mean that it will be granted. The classic case is where guardianship was given, case closed, and the person wants to terminate the guardianship and get the children back. The only way to do that is by filing a 388 in the court that granted the guardianship, and that would be the CPS court.
But usually,
I get calls about that all the time.
but that means those are the ones that did not get terminated of their parental rights.
Correct.
Okay, got it.
But
Mhm.
at the beginning of the show, I told you about that case in San Diego where parental rights were terminated. The child was adopted. And because of some very unique facts, the mother filed a 388 and got the child back and got the adoption reversed.
That's
Very,
just
un-
that's just
very,
a very
very unique facts, though.
yeah, that's like a miracle. That's really a miracle. If the judge grants the 388, what happens next?
You mean, well, if they grant a hearing, you have a hearing. But if you win the hearing, the judge makes orders and gives you the relief you're requested. For example, you get more family reunification services, or the child's moved to a relative, or the child's returned to you, or you get liberalized visits like weekends and overnights. It depends on whatever relief you ask. If the judge agrees with it, that's what you get.
So what if it was denied? What happens next?
You don't get what you ask for, and you and your attorney have to decide whether you should file a notice of appeal.
Now, can a parent later on appeal that decision if it was denied by the judge?
If it's denied, you have 60 days to file a notice of appeal.
60 days in California to file a notice of appeal, but we don't know about other states, okay?
No, correct.
What would you say to a parent watching who's afraid to file but knows they need to?
Fear is false expectations appearing real.
Oh my goodness. Yeah, I sent you that before. That is so true. Why is the 388 petition one of the most powerful legal tools in dependency court?
Because it allows you to correct your mistake or the court's mistake or the social worker's mistake.
What should someone do tonight or tomorrow morning if they're ready to act on this 388 petition? And I'm done with my questions.
Talk to their attorney or give me a call. You're done with your questions? That's perfect, because the time is up and I am on my way to court.
Where are you going? What county?
I have a case at Monterey Park, the CPS court, and I have a case in Pasadena.
Good luck. God bless.
Alrighty.
All right.
Thank you very much for co-hosting today, and we'll see everyone tomorrow at 6:30 a.m. Pacific time for more of my office hours. Have a good day, everyone.
Bye-bye.
I I'm very, very pleased with Mr. Davis and so far the outcome of the case and how he's been there for me. He's been by my side. Like I said, he's really gone above and beyond. He's an amazing, amazing attorney, an amazing person as well.